Tonight, surprise move from Donald Trump in the Georgia election subversion case. The former president says he will no longer push to move his case from state to federal court. So let's dive into all of this with CNN legal analyst Norm Eisen. Norm is also the former House Judiciary Special Counsel in Trump's first impeachment trial. Also here with us, attorney and former D.C. Democratic Party Chair A. Scott Bolden. Gentlemen, great to have you with us tonight. We appreciate your time. So, Norm, Trump and his lawyers decided that they will not move forward to try to move the criminal charges into federal court. Does that surprise you?
It does, because they told the court, the state court, that they were going to remove. The thing that changed, Pam, is that Mark Meadows has been a trailblazer on removal, and he lost. And it makes sense that he lost, because you only get to go from state to federal court if you were doing official action. And attempting to overturn an election, as Scott well knows, cannot be an official act. In fact, under federal law, the Hatch Act, those kinds of political activities are by definition unofficial. Right. Trump didn't want another big loss like he's faced in D.C. federal court, in New York state court, so he pulled the plug.
It won't work under any circumstances, under any court, undermining democracy and trying to change elections and stuff.
And, you know, we should point out a big difference between federal and local court is that federal court, you don't have cameras in the courtroom. Yeah. Local court, this court, that's going to be a different
and you have a broader jury pool,
right?
Too.
Broader jury pool, that's
from
an
different
important
jurisdictions. And the state court would be Fulton County, which is a big Democratic stronghold. Not that politics is going to invade the criminal justice system, but you're pulling jurors from that voting electorate, and that's really, really important. You're going to have the cameras. And, you know, Norm, one of the really interesting things is that this trial is going to play out during 2024. And whether you're a MAGA supporter or whether you're a Republican or Democrat, you're going to see the criminal justice system at work, constitutional issues, but more importantly, you're going to hear the facts in real terms with witnesses as to what happened and how they tried to undermine this election. And it's going to educate a lot of voters, I think, whether they want to be educated or not. The criminal justice system is going to work, and it's not going to be a political process. You're going to see facts that really show how dangerous these acts were.
And we could see Trump testifying live on television, right? I mean, that's a possibility.
It is. Scott and I have made
I don't think he can testify
for a lot of years, telling clients, do not
testify.
I know,
but
it's very
Trump,
unusual.
And he's not been known to listen to his lawyers, but you're right.
That is part of the reason, actually. The testimony question, I think, is part of the reason that he opted not to remove, because if he had removed, Mark Meadows testified, he injured his case very badly with some of the things he said. Trump would have had to testify. His lawyers, pretty smart, said, well,
we're not going to play out. They said
we're not going to do that yet.
Yeah, but it gets even worse with Donald Trump, though, because whether it's the Atlanta trial or the federal trial or the New York trial, Trump's public statements, the attacks on the judges, the attacks on the prosecutors, his interviews with the media where he talks about these cases and he makes these party admissions. I think in federal court, you can get those party admissions admitted. I don't think there's any way he gets on the stand, because it'll take 3 days just to cross-examine him on his prior inconsistent statements. Now, he's got to do that because he's running for president, but his campaign are these criminal cases, and the criminal cases are his campaign. It's really weird.
I want to talk about a situation where he could take the stand, where he could testify, and that is that $250 million civil fraud trial in New York set to begin on Monday. The New York Attorney General released a list of witnesses, including Trump himself and his children, Ivanka, Eric, and Don Jr. How do y'all see this playing out?
Well, the situation is different in a civil case, because unlike in a criminal case where Donald Trump has the right to take the Fifth Amendment without injuring his own case, in a civil case you get what is called an adverse inference. That means if Donald Trump refuses to testify, if he's called, he takes the Fifth Amendment. Under certain circumstances, the judge can say, well, I'm going to hold that against you, Mr. Trump. This is Judge Energon already very severe on the president. So we will see how these issues play out. I think Trump is in a world of hurt in this civil fraud case. What is more important to him, Pam, than his businesses, his brand, and his name? That is being taken away from him, it seems, by the judge in this case.
Yeah, the receivership is really going to be harmful. The judge has already taken away his business certificates. I'm not sure how they're operating. It's up on appeal. That's probably how they're still operating. But this hits the pocketbooks of not only the company, but these individuals. And the civil justice system, he's got to testify. I know there are exceptions, but the kids have got to testify, because if their testimony is deemed to be relevant, probative, and material, they're going to take that stand. They're going to get subpoenaed. They're parties to this lawsuit. And the civil justice system just won't allow any shortcuts to discovery and sworn testimony. Look for that testimony. If they do testify, look for that testimony to find its way into these criminal trials.
All right, we'll be watching all of this very closely. Great to have you all on here and your perspective. All right, thanks so much.